Thank you very much. So, good morning. It is our task to both cover the issues and to stay on schedule. All right, good morning. My name is Esther Brimmer. I'm Executive Director and CEO of NAFSA, the Association of International Educators. We are the world's largest and oldest association of people involved in the exchange of students and scholars. We also we would argue that international education actually can contribute to creating a globally prepared workforce. In fact, I will always take on the previous panel and say we actually do think that you can help teach flexibility and nimbleness by placing people in unfamiliar situations and having them succeed. One of the benefits of international education is precisely being in situations that are unfamiliar, learning while you are abroad, or learning from internationalization on your campus. So I think we're all going to talk about some of the skills that we think that you can learn and how you think we can learn them. And we would argue in NAFSA that international education is a fundamental component of an excellent education, and we'll explore that in detail. So we would suggest that whether you are managing a multinational team or having to deal with uncertainty, that international education is part of that. But the framework matters. And so this session is about the changing legal environment, about the developments, the opportunities, and the risks that we see. And we'll hear from our two expert panelists on this topic. I'll just note that from the international education perspective, we see real risks on the regulatory side. We recognize that the contribution of international students and scholars to the United States is crucial, and many of you who are from campuses know that your international students are part of the success of your institutions. International students also contribute 450,000 jobs and almost $39 billion to the United States economy. International education is the 6th largest export of the United States. But regulatory and policy changes that we see now are affecting the ability of people to study in the United States and the ability to keep the United States open and welcoming. We're concerned both about curricular practical training and optional practical training, the ability to stay and work after you study. We recognize that regulatory issues such as enhanced penalty provisions, changes in the definition of unlawful practice that could lead to bans from the United States are a real issue. And we note that the Council of Graduate Schools just published last week noted that there has been a decrease, a 3.7% decrease in first-time graduate enrollments of international students, and a 2.4% decrease in total graduate enrollments of international students, second year in a row. So the regulatory environment is certainly affecting international education. It's having effect on campuses and the ability for them to do exactly what we're talking about, creating the globally prepared workforce. So understanding the changing legal environment is going to be crucial to understanding what universities and businesses can deliver. And to discuss those issues, I'd like to turn to our experts. Christina Riggs is Vice Chair for Higher Education Practice at Saul, Ewing, and Stephanie Gold is Chair for National and International Education Practice at Hogan, Lovells. So we're going to, each is going to speak for about 15 minutes, and then we will have questions and answers. So Stephanie, would you like to come to the podium?
Great.
And your slides are up. Yes.
Yep. So I'm Stephanie Gold, and I just have to say initially, I'm almost 50. I've rarely met someone with the last name Gold except my immediate family members, and there are 3 Golds on this conference, which I think is a record. Okay, so I'm going to talk today about innovation in education and how the regulatory framework relates to those innovations. And in the course of discussion, I'm going to talk about some of the, give you an update on federal policy that's pertinent to higher ed. So first I'm going to provide an overview of the regulatory framework, and then I'm going to talk about 3 particular innovations in higher education: distance education, competency-based education, and increased access through novel models for the delivery of education. So first, to level set, let's just talk about the regulatory framework that applies to higher ed. The regulatory framework is often referred to as the triad. There are 3 primary components to it: the U.S. Department of Education, accreditation, and state education licensure. The triad is critical for purposes of federal student financial aid, which can be an important component to access to higher education. And the federal student financial aid programs, you'll often hear them referred to as the Title IV programs because they're authorized by Title IV of the Higher Education Act. So the U.S. Department of Education administers the Title IV programs. It approves institutions to participate in the programs, and it's responsible for monitoring institutional compliance with all of the myriad of regulations that apply to the federal student financial aid programs, and it's also responsible for safeguarding the federal government's financial investment in higher education through those Title IV programs. So in order to participate in the federal student financial aid programs, a higher education institution has to be not only approved by the Department of Education, but in order to get that approval, it has to be accredited by an institutional accreditor that's recognized by the U.S. Department of Education, and it has to be authorized to offer programs and award degrees in the relevant states. In general, in addition to overseeing state post-secondary education, state agencies, state education agencies perform a consumer protection function with respect to independent, not-for-profit, and for-profit institutions. So a post-secondary education institution has to be licensed by the appropriate state education agency or agencies in order to operate in a state or to award degrees in that state to residents of the state, where it's physically located. So states have different statutes, regulations, and practices that typically require registration or licensure based on whether or not the institution has a physical presence in the state. But every state has the beauty of our system. Every state has its own way of thinking about physical presence. And this can become challenging as institutions operate state by state, as we'll talk about in the context of distance education. Accrediting agencies are private, non-governmental organizations, and they conduct peer evaluations to assess whether a particular institution meets the organization's standards of quality and to assist an institution with self-improvement. So there are institutional accreditors that accredit institutions as a whole, and then there are programmatic and specialized accreditors that accredit particular programs. Institutional accreditation is what is required to participate in the federal student financial aid programs. Programmatic accreditation is typically more relevant for purposes of professional licensure. So the regulatory framework has presented challenges to higher education, largely because it's driven by provisions in the Higher Education Act and U.S. Department of Education regulations that assume that institutions are delivering very traditional education in terms of the construct of the programs and how they are being delivered to students. So it becomes difficult when you're looking at newer models of education to fit them within that requirement, within the triad of what applies, particularly with respect to participation in the federal student financial aid programs. This situation was recently addressed by the Department of Education's Office of the Inspector General in a letter that it wrote to the chairs and ranking members of the congressional education committees that are considering reauthorization of the Higher Education Act. And specifically, the OIG stated that it's imperative for Congress to address long-standing and emerging challenges, amend outdated Higher Education Act provisions to address awarding and dispersing aid in distance education and other alternative educational environments, and continue to provide for accountability, all while not stifling innovation. So this statement very much sums up the needle that the federal policymakers are trying to thread, while also reflecting the realities of what higher education faces in the regulatory context. So distance education is a good example of an area where this tension can arise between regulatory accountability measures and innovation. So because distance education takes place with the instructor in one location and the student in the other, the Department of Education over the years has identified particular challenges with respect to administration of the federal student financial aid programs and distance education. The Office of the Inspector General of the Department of Education has testified before Congress approximately 5 times since 2005, specifically on the topic of the susceptibility of fraud and abuse in the context of distance education and the financial aid programs. In a 2014 report, OIG identified a number of challenges related to distance education, including how to verify a student's identity, how to determine whether the student is in attendance at an academically related activity, and how to maintain sufficient evidence of a student's actual academic attendance. So the Department of Education has addressed distance education in various ways that have created challenges and arguably have caused some impediments to innovation in distance education. So the first relates to how distance education is defined and how correspondence courses are defined for purposes of the federal student financial aid programs. There is a rule that says that if more than half of your courses are correspondence courses, or more than half of your students are enrolled in correspondence courses, then the institution loses eligibility to participate in the federal student financial aid programs. It's called the 50% rule. So it becomes very important to be able to distinguish between what is distance education and what is correspondence education. The federal regulations describe the difference between those two. They say that distance education is education that uses certain technologies to deliver instruction to students that are separate from the instructor and to support regular and substantive interaction between the students and the instructor. For correspondence courses, in contrast, it involves interaction between the instructor and the student that is limited and is not regular and substantive, and is primarily initiated by the student. The problem then, so the key distinction is that concept of regular and substantive interaction between the instructor and the student. The problem is the law doesn't define who is an instructor, and the law doesn't define what is substantive and regular interaction. So this can become very tricky then in practice when you're trying to develop particular sort of online education models. Most notably, this came up in a 2017 U.S. Department of Education Office of the Inspector General audit of Western Governors University, where the OIG reviewed 102 of WGU's online courses and determined that a number of those courses that WGU had characterized as distance education should be characterized as correspondence education, and that as a result, WGU had violated the 50% rules. The OIG recommended that the department hold WG liable for all of the federal student financial aid that it had dispersed since it had lost eligibility in the programs in 2014, which would have resulted in about a $700 million liability over that. And largely the way the OIG thought about this was because of the way WGU has structured its instructor model, sort of taking the different roles of an instructor and divvying it up among different roles within the institution. And from the OIG's perspective, as a result, it meant that there was no instructor that was having regular and substantive interaction with students. Not surprisingly, WGU disagrees with the OIG's determination. It views this as a challenge to its innovative model. The OIG has no independent enforcement authority, so it can't actually act alone to enforce this decision, and the enforcement arm of the Department of Education at this point hasn't taken the OIG up on the recommendation. Another area of distance education that's gotten a lot of attention is state authorization. This has been a long and somewhat sordid saga in the regulatory world. State authorization has for many years been a state issue, meaning that as a matter of state law, institutions that were operating across borders had to get approval to operate in a state if that state required that approval as a matter of state law. In 2011, the Department of Education made this a federal issue. When the Obama administration promulgated a regulation that basically said in order for an institution's programs to be Title IV eligible, the institution had to have approval from all states that would require it to have approval for purposes of distance education. A court struck down that provision, not on substantive grounds, but on the ground that the department hadn't followed the proper process in promulgating the regulation, so the Obama administration went back to the drawing board to put together new regulations. In the meantime, an organization called NC-SARA was developed, and NC-SARA, it stands for the National Council for State Authorization Reciprocity Agreement. And the idea here, the concept behind NC-SARA is because it was so complicated for institutions to have to go state by state by state to get approvals. It just can be a regulatory burden. It can really create a lot of cost for an institution. The idea with NC-SARA is that states would agree on a certain minimum set of standards that all institutions would have to satisfy, so that if you're licensed in your home state and your home state participates in NC-SARA, then all the other states that participate in NC-SARA will recognize that licensure and will not require you to get separate licensure from their state. At this time, all states but California participate in NC-SARA. This means that if you're an institution in California, you still have to deal with the burdens of getting licensure in all of the states in which you operate. And let me tell you, the states have gotten, with the federal government's interest in this topic, they got smarter about the need for state licensure, and more states are requiring state licensure than maybe did, say, 20 years ago. If you're an institution outside of California, then you can get the benefit of NC-SARA. If you get approved to participate, you still have to deal with getting approval in California if California requires you to get approval. At the federal level, state authorization for distance education is still an evolving issue. The Obama administration did issue new regulations very shortly before leaving office. Those were scheduled to go into effect July 1, 2018. Within days before going into effect, the DeVos Department of Education announced that it would delay the effective date of those rules until July 1, 2020. And the department announced that it plans to do a rulemaking that will address state authorization and distance education. In the meantime, the department has been sued over its action to delay the Obama administration rules on the grounds that they weren't authorized to do that. So the saga continues with respect to state authorization and federal student financial aid. Okay, I'm going to jump ahead to talk about competency-based education. So competency-based education is another innovative area for education that involves generally academic content that's organized around competencies and measuring academic progress in terms of learning outcomes. The challenge with competency-based education is that even though as an academic matter you may organize your competency-based education program in that new way around competencies, if you want the program to be able to get federal student financial aid, you have to fit it into the existing framework for federal student financial aid, which again is a very traditional model. So you still have to figure out how your competency-based education program translates into a credit hour program or a clock hour program, which is how the Title IV rules currently really address education programs from a Title IV eligibility perspective. So you end up having to take kind of a square peg and putting it into a circle hole in order to get a competency-based education program eligible for Title IV, which for some, it can feel like you're sort of defeating the purpose of this novel education model. And the last area that I'll mention is on increased access to education. So this is an area where there's a federal student financial aid rule that basically says that a non-Title IV institution can offer no more than 25% of a Title IV institution's program and still be eligible for financial aid. If it offers more than 25%, it can be no more than 50%, and it has to be approved by your accreditor. There is a U.S. Department of Education experimental program right now that's looking at allowing institutions to not have to comply with that rule. They've approved one arrangement that involves Straighter Line offering more than 50% of a program for a Title IV institution. Straighter Line is an online course provider that's not Title IV. And then there is the Council for Higher Education Accreditation is serving as the quality assurance monitor for that program. The department had they had looked at, I think, something like over 10 possible programs to allow participation in this experiment. The challenge again has been that the experiments have to still satisfy all the other federal student financial aid rules, even if they're able to get this one particular rule waived, and that has proven to be a challenge because some of these non-Title IV providers, the way they're delivering their courses doesn't really fit with a traditional model and therefore doesn't fit with the traditional Title IV rules. Let me just wrap it up that on both of these fronts, both on competency-based education and on this topic of novel partnerships between non-Title IV institutions and Title IV institutions, the DeVos administration has said that it is going to engage in a rulemaking to amend the regulations to try to address these innovative models of education. So I would say that you should stay tuned and stay informed. It's also an area of interest for Congress as they reauthorize the Higher Education Act. And then I'm also available, there's been a lot going on at the federal level with gainful employment rules that you've probably heard about, as well as borrower defense to repayment. And I'm happy to answer any questions you may have on those topics, even though I wasn't able to talk about that at all. Thank you.
All right, so for anyone that thought that they could come to a higher education conference and not hear something on Title IX, I'm sorry. It's not possible. So, engaging in rulemaking, right? That's exactly what we've been waiting for about a year. We had talked a little bit about the regulatory environment, the change that's coming. This is one of those situations that Title IX, it sounds like a very unique and specific thing, but recently we know that the new administration rescinded what the Obama administration had done, had promised new regulations. We are really hopeful that they are coming down as early as this week. So if someone notices that while I'm talking, the new regulations have come down, just raise your hand, let me know, and I can just sit down and we can save some time. But what I'm here to do is talk about the leaked regulations. So some of you may have heard that there were regulations of the new proposed draft that leaked in August. In that, it has very specific changes that we might see on the horizon in Title IX. So I'm here to talk about what we saw in those leaked regulations, which I have here, if anyone wants to look at them or see them. I am cautioning all of you, right? These are drafts. So what I say today is something that is contained in the draft version. We don't know if it will actually be in the final version that comes out. But what the final version will do, it will go through the rulemaking process, which was the problem that they've identified with the way that the Obama administration had gone through it, which was to do it via the Dear Colleague letter. So this will go through notice and comment period. So what I'm going to do is try and highlight really quickly in 15 minutes the areas that we might see some changes. And that will give you an insight into whether or not this is something that on your campus you may want to comment on. You may want to find a group to comment on your behalf. And you may want to even just start strategically thinking, right? This is what happened. Okay. So, and I'm one person that tends to move. I will try not to, but sorry if I do. This is your quick getting up to speed. We had the Obama administration guidelines. That was basically your 2011 DCL, your 2014 Q&A. In September of 2017, that was rescinded. The Trump administration says you can't work that way. You have to go through a notice and comment rule. You can't just do a DCL. You can't just do a Q&A. But then the Trump administration on that same day issued a DCL and a Q&A that basically was deemed interim guidance. But they also said on that day, we will be going through notice and comment. We will give you new regs. You will get an opportunity to comment on them. Well, that happened almost a year ago. Then there was a leaked document that happened in August, and panic has ensued, all right? So people are, oh my gosh, did you read the leaked regulations? Oh my gosh, do we need to make all these changes? What do we need to do? Is everything going to be flipped on its head? I am here to tell you that think strategically, okay? Look at what the changes are. Some of them will be mandatory. Many of them will be permissive. okay? What I would encourage everyone at your institutions to do is to think about what makes sense on your campus, right? Because we've already had reference earlier today to the Me Too movement. We know when we're talking in the Title IX world, we also have to think about the respondent litigations. That's the person that is accused of violating your policy. And so you want to think about, do I need to make these changes on my campus, right? Which ones do I want to change? Because you really do want to think about protecting your campus. That is your goal, okay? So I'm going to walk you through each of these and encourage you, don't panic. I think that you will see slow changes on the campus, but a lot of what you have already done on your campuses is ingrained. It's ingrained not only in your administration, but it's ingrained in how your students perceive your grievance procedures to go. And so what we really want to do is think about which changes we on a campus want to make. The reason I think it's important here, though, one thing I'm not going to put in my slides, but I want to highlight to everyone that's here as one of the changes or statements that's going to be suggested to be placed in there is, in the draft regulations it says this: we also propose adding a provision to clarify that the policies and grievance procedures described in this section need not apply to persons outside the United States. Okay, that sounds shocking, right? Well, the Title IX statutory language actually says that it applies, quote, to persons in the United States. End quote. There is also legal precedent. There was an MIT case, we're talking about distance education, where an MIT student went through the court procedures and it was determined that Title IX didn't apply to that particular student, okay? I will caution all of you, it's very restrictive analysis, okay? So when you see that in there, need not apply to persons in the United States, and the only precedent we have that's ever applied that, the individual was going through distance education, but they never set foot in the United States. The distance education was more limited, so perhaps it was deemed distance education. It could have been a correspondence course, but there was limited interaction between that particular student and the United States, and everything that happened outside of the United States. So when you see that provision in there, two things. One, it's not going to, I don't believe, really change how you apply it at your campuses, and two, it's permissive. It need not apply. You can, of course, say that we will apply our own Title IX grievance procedures to any student within our campus. And so I caution you on those two pieces, because you might see that. All right, so I'm going to try, like I said, in 15 minutes to hit the highlights. All right, legal standards. This is probably interesting to only the attorneys in the room, but I can tell you that the Department of Education, should they come onto your campus and go through one of their program reviews, will be applying the delivered indifference standard, if the regs are to be final in this way. The delivered indifference standard basically is an actual knowledge. It says that you cannot act in a manner that is clearly unreasonable. So it's a favorable standard for schools when trying to assess whether or not Title IX is violated. Safe harbors, this is a section that I think everyone's going to want to take a look at. The safe harbors is basically, so what the department is saying is they believe that their regulations will actually save you money. Because what they're saying is they will minimize the number of investigations that you have to do. That is what the draft regs suggest. Whether that will actually happen, I don't know. But one of the areas that they think will end up helping is that they are going to require that if you, as a complainant, want to go through the school's formal grievance procedures, you have to file a formal complaint. Right? So you have to basically sign something. I would like you to investigate this. That is not what we have seen before, right? You could simply bring up a notice or an informal complaint to somebody, and that would trigger the school's investigation. There are additional safe harbors in there about when you have to act if something is completely private and off campus. And then there are also some mechanisms that allow for more use of informal resolution as opposed to formal resolution. Okay. Interim suspension. I just want to talk on this for a second. So interim suspension is the concept that we have a report. We are going to investigate that report. But in the interim, the report is so egregious that we want to make sure that we get the respondent off our campus. We are going to suspend you during the interim so that we can go through the investigation procedure and decide whether or not you are deemed responsible. That is still permissive, That will still be permissive according to these regs, and same with employees, you could put them on administrative leave. The only difference is that the regulations seem to be suggesting that you will have to offer some notice and comment, or notice and opportunity to respond mechanism, and that is right away. So that means I want to interim suspend you, student. That student gets an opportunity to respond, an opportunity to be heard. For you public institutions, that sounds common, right? You have due process. For you private institutions, you're not necessarily bound by that. But this will be placed into the regulations such that you might have to develop almost a mini hearing that happens before the formal hearing based solely on the suspension itself. So that is an area that I think we're going to see some comment on. All right, grievance procedures. So a couple of things highlighting. Everyone goes through this standard, right? What standard are we going to have to apply? So we know Title IX currently says you have to apply preponderance of the evidence. That's, think about it, 50.1%, right? And then there's clear and convincing. What the regulations seem to be saying is you can use preponderance of the evidence if you want, if you apply that same standard to all other forms of discriminatory conduct. So, if that's the standard you apply in other discriminatory conducts in your employee handbook or in your student code of conduct, you can apply that as well. What the sort of caution is, think about it, so some of your, and this will apply less for students and more your employees. So sometimes, depending on if you have tenure faculty or you have various labor forces, we have it worked in that you apply a different standard, that to some of them you might be able to, in their procedures, use clear and convincing. If that's the case, right, you're going to have to apply clear and convincing for everybody, or you're going to have to change that model. So the standard, you can still use preponderance, but it's going to have to be, according to the regs at least, equalized along all lines of discriminatory conduct. The appeal, interestingly, right? So we know that there were times where you would only give the appeal to the respondent, then you had equal treatment, you give appeal rights to both parties. What the regs actually say is that you can give an appeal right to a respondent or to both parties, and if you give it to both parties, then the process has to be the same. So that's what they suggest. I still think that this is one area that if you've got your process down, sometimes it is easier to just apply it. You're going to apply it to one party, apply it to both. I think this is their way of suggesting that trying to not rehear the entire thing and basically have the respondent go through the process twice. So the regulations seem to suggest that that's the case. I think there's an ability that they're trying to slice their way between respondent rights and also staying in line with Clery, which says that if you have a process for both, it has to be equal. I do think this is an area we might see some comment on as well. And lastly, giving them notice of the outcome. There is provisions in here that make it a little bit more elaborate on what you're going to have to tell them. Basically, what the investigation was, what information you had, what was the rationale for your outcome, what was the rationale for your sanctions. It reads almost like a finding of fact and conclusion of law for those of us in the legal world. I think via Clery, many of you are providing more substance in your notice letters to students anyway, so I don't think you're going to see much difference there. All right, so just a couple of other things. Grievance procedures, talked a little bit about the equitable treatment. Presumption, I'm going to jump down to that one. So what you are going to have to do, according to the regulations, is that whenever you give notice of student X, we have come across a report that you potentially have violated our student code of conduct for sexual misconduct, there is a presumption that you are deemed not responsible until the conclusion of the hearing. So it's sort of the presumption of innocence, right? That will have to be a written piece in your notice letter. Time frame, sanctions, and supportive measures, that's in there. That's not going to change because they're trying to come in line with Clery. So basically what it says is the 60-day rule of trying to get your investigations done in 60 days, which that was difficult. The department couldn't even keep up with that, and they recognize that. They do say that you have to put your timeframes down, reasonable timeframes. If you have need for delay, that's fine. You just have to give written notice to both parties. That's pretty much in line with Cleary. Same with sanctions. You do have to provide a list of the potential sanctions, so that's not up to and including termination or up to and including suspension. That is a list of here are the potential sanctions. And then the range of supportive measures. So that's the difference between the two. Sanctions, you have to do a list. Supportive measures, you can do a range. All right, so notice of allegations. Two things I want to point out here. So these are the things you're going to need to do. Sufficient details. There is going to be a big push to see more information placed in your notice of allegation letters. Sufficient time to prepare a response. We're already seeing that. That same presumption letter is there as well. The last thing is information on disclosure of evidence requests, which I'm going to get to on the next slide. But the last thing I want to say on this one is, this happens in your investigations all the time. So you get a report of an allegation. You give notice, you start your investigation. In the course of that, you get notice of a second incident, or an incident that happened on a different day. You've got to go through this process again. Because otherwise that respondent is responding to something without the full benefit of what it is they're being alleged to have done. So that part, I don't think will change. I think that will stay, so that's something to take note of. All right, so the investigation highlights, jumping over to this last one, I said disclosure of evidence. So, if a student requests it, what they're saying is a school has to promptly give them any piece of evidence that they got during the course of their investigation. All right? That includes information that they don't intend to rely upon. That's a little bit different. That sounds almost like a criminal proceeding. Right here is all the evidence that we uncovered. Traditionally, what we've seen is any information that's going to go to our board, right, or hearing panel, is made available to the parties in advance. This is everything that is collected. So that's at least what they're suggesting right now. Okay, jumping back over, collecting of evidence. Whose burden is it? Traditionally, we say, hey, students didn't give it to us. According to the regulations, they're trying to put the burden on the school to collect evidence from the parties. I think we'll see some notice and comment about that. What does that mean? Can we just ask them and they don't give it to us? That's that. So I think we'll see some comments about that. Discussing allegations, a lot of times we tell the parties, right? This is very sensitive, this is very confidential, don't talk to anyone. There is a suggestion in the language right now, or in the regs, that says you can't do that because you're now inhibiting the respondent's ability to go collect evidence and talk to witnesses. Hearings, okay, this is without a doubt going to have some comment associated with it. The idea of cross-examination, right? That has always been an issue, right? Do you allow the one party to cross-examine the other party, directly question them? The idea has always been that you are placing the complainant in a traumatic environment if you allow the respondent to cross-examine them. The flip side of that is the respondent says, I have to be able to cross-examine the person that has accused me. And so what we've seen is we provide a list of questions and they go through a panel member, right? What the regulations are saying is this. If you have a hearing, you must permit cross-examination. They don't tell you what cross-examination means. If you don't have a hearing, you have to allow written questions. This is an area that I do think we're going to see some notice and comment on, and I would suggest you to read those provisions in the drafts and also in the new ones, which could come down any moment. All right, I think I have 1 minute, so I will just tell you this. OCR remedies, when OCR comes onto your campus, they won't, or can't, according to the regulations, be looking for monetary damages anymore. Okay, FERPA, we always have that concept, FERPA's head 9, FERPA's head 9. The regulations will say, Title IX trumps FERPA. Religious exemption, it will now be self-executing, which means that school can basically just execute that they are religious exempt and they don't have to inform the department about it. Constitutional protections, we will see some notice in regulations, and there will be notice and comment about it, about how Title IX intersects with First Amendment and due process rights. Mostly for public institutions, but private institutions should take note because sometimes there can be some applications. So that's that.
We will now have time for questions and answers. I want to thank both of the panelists for covering a lot of information in detail in a short period of time. I would like to say that both panelists will be here throughout the day, so you will have an opportunity to ask them questions if you're not able to ask them questions at this time. And I'd like to take questions. Please introduce yourself when you ask a question. So, first question.
answered all of the questions.
Well, I had one. Is, in light of we're trying to solicit one recommendation or takeaway you have for today, what would each of you say, Esther, including yourself, what would each of you leave us with one thought?
So for me, because I talk on a very, very narrow topic,
Can you use the microphone?
Oh, you push the button, it'll go, when it's green.
There we go, all right. So for, my topic was very, very narrow. So it would be, take a breath when the regs come out. Read them. Talk to those in your campus that handle your grievance procedures, that handle your investigations, that interface with your students and your faculty in terms of supportive measures. Because there will be things that will change fast, and there will be things that will change slowly, and there will be things that probably won't change at all. But I think it's really important in this environment that you think about how your students will perceive and your employees will perceive the quick actions.
So I would say my takeaway is that it's important to bear in mind what the regulatory framework is when you are looking at these innovative education models, and it is hard for the policymakers to wrap their head around what it means on the ground, what these models entail, and to help them by educating them and to help them figure out what the solutions are in terms of what modifications are needed in the Higher Education Act and in the federal regulations, because it's very easy for the policymakers to ultimately go back to what they know, which is effectively a very traditional model where you've got 18 to 22-year-olds living on a residential campus who are taking programs that are structured in terms of semesters or quarters, and they're working their way through to a degree at the end of 4 years. That's not where a lot of people are going, and the regulations, though, are really lagging and keeping up on that, and I think part of it is educating the policymakers.
I would also say, in terms of educating policymakers, precisely the impact of the proposed regulations, whether those that we've discussed today or some of the other things we've seen, and we've flagged particularly whether it was the travel bans or on these actions that are making it more difficult to actually obtain visas for international students to come to the United States. These are all part of creating innovation on campuses to create the skills that we need for the globally prepared workforce. And so that if there are measures that are affecting the ability to do that, those will have serious implications. So we need to help policymakers not just go back to know, what they think they know, which may not be accurate. And so making that clear is important. Question to the gentleman over there. And please introduce yourself.
Hi, my name is Dick Bell. A question that I would sort of like to throw out for the group, and if anyone feels qualified to answer it, I certainly don't. But I'd like to just ask a question about distance education. Distance education potentially offers opportunities for people to get skills that the business community needs who might not otherwise be able to attend school or have traditional education. On the other hand, we hear intermittently about the fact that people are not necessarily getting the skills that they think they're going to get when they sign up for distance education and are not able to find jobs. And some, I think, are even taking legal action against the entities that educated them. So I wondered if there's anybody here who can sort of make an overall statement about the extent to which they think distance education has provided a pipeline to the business community that is robust or may not have existed, previous to the past 10 years or so. And how effective has that been in supplying the business community with people with the skills that they need?
Hi, I'm Susan Aldridge, and I'm Senior Vice President for Online Learning at Drexel University. This is my third university and 22 years in adult and distance education space. So what I would say is that with reputable institutions that have solid academic programs and rankings with distance education programs, this is such a highly regulated environment these days. But if the institutions make the investments in the quality of the programs and the faculty and train the faculty, we can provide extraordinary quality. So at Drexel, as an early pioneer, as a nonprofit university here in Philadelphia, we have over 1,000 LOUs with companies and associations that pay a portion of the tuition of their employees to come to our academic programs online. This is just solely for the online programs. So we're able to help map to industry what they need in areas like master's degree in clinical trial research and master's degrees in drug discovery and in many non-traditional areas of compliance, where companies are sending their employees back to school to ramp up in new areas like cyber and privacy from our law school, for example. So companies are not necessarily looking for full degree programs. Some of them are looking for academic certificates and a number of courses that really give the company an opportunity to obtain the knowledge in a relatively short period of time. So we see that this is increasing substantially because they don't want their employees to leave their billable hours or leave their place of employment, and particularly with family obligations and everything else. There are quality distance education programs that are available, and students just need to do some research about them, and the companies need to do some research about them. But if the companies can create a list of preferred providers for their employees through their HR department, that helps steer the employees, I think, to the organizations that have the type of credentials that the company is seeking. I hope that answers your question.
And can I just add one little note on that? I do a lot of work with the universities that are engaging in online initiatives and contracting with online program management companies. From my perspective, I think the biggest challenge for higher ed institutions is that they're not always thinking strategically about their online offerings. I think Drexel is a real, really top of the class in this regard, but I find a lot of times institutions view online education, this is going to be a panacea for our revenue generating needs. And they'll just put another MBA program online. And that's just not necessarily going to be the best strategy for the university or for business. And they really need to be thinking about what strategically makes sense for our institution. And it's very regional. It can be very much. You shouldn't be trying, if you're an institution in Pennsylvania, don't be trying to get the students necessarily in California. You are going to have a bigger brand recognition in your region, and you're going to be able to serve your workforce, the regional workforce needs greater if you really think about the online education programs that you're developing. And so I repeatedly tell institutions they just need to be smarter about what they're doing online.
That's a great way, I think a great takeaway from this session, which is thinking strategically to operate in the context in which you are. So again, please join me in thanking the panelists who give